You're listening to Autumn on the Air, the weekly podcast that brings you conversations about the impact of research commercialization and the people who make it happen. Join us for interviews with patent and licensing professionals, innovators, entrepreneurs, and tech transfer leaders on the issues and trends that matter most. Keep listening for an inside track on the people, IP policies, and politics changing our world.
Welcome to Autumn on the Air. Today we're exploring an often misunderstood aspect of tech transfer, the strategic licensing of know-how. I'm joined today by Wes Blakeslee to deep dive into licensing of know-how. Wes holds an engineering degree from Penn State University and a law degree from the University of Maryland School of Law. Wes has extensive experience in intellectual property and business law, having served more than 15 years at the Johns Hopkins University, where he was an Associate General Counsel and later Executive Director of Technology Transfer. As a certified licensing professional, Wes frequently speaks at conferences and consults on intellectual property and business matters. Welcome, Wes. I'm so excited to have you here on the air.
Well, thank you. I'm happy to be here.
Well, we have a lot to talk about today. We're talking everything about know-how licensing, and I thought maybe the best way to start things here is for you to share a little bit about your background and how you became an expert in know-how licensing.
Well, I'm an engineer by trade. Started my professional career as an engineer with NASA, the National Aeronautics and Space Administration, but then later turned to the dark side and became a lawyer. So early on in my legal career, because of my engineering background, my work involved matters with an engineering component. I started with a large law firm. Ultimately, I opened my own office in 1982, and not long after that, I acquired a client who I still represent today that does classified research and development, primarily around military projects and primarily for the federal government. My client designed and created the products, but if the government decided to deploy those products, then we licensed the know-how to those companies so they could then produce the products for the federal government. There were no patents because this was all classified work, and so we licensed pure know-how, the processes and the technical specifications that were needed to make the product. So that's how I started getting involved in licensing know-how and started to learn the nuances and distinctions. And of course, my career progressed from there. I started doing a lot of this kind of licensing and dealing with intellectual IP, which ultimately led me to the Johns Hopkins University, where I was initially in the general counsel's office and then finished as the head of the tech transfer office before I retired. And of course, now I do consulting and legal work in this area.
Well, that's a really fascinating background. I haven't met too many people who have had that extensive experience in know-how licensing. So amazing journey that you've had, Wes. So let's get into the weeds a little bit here and talk about what know-how really means when we're talking about the context of technology and research.
Well, in its simplest terms, know-how is something you know and others don't. When we define the term trade secret, we usually add the words that gives you an advantage in the marketplace. So something you know that others don't that gives you an advantage in the marketplace. But trade secret is a legal term for know-how that gets protected by law. And so it has those additional layers, one of which is that to be protectable as a trade secret, you must treat the know-how as a trade secret and take steps to protect the secrecy. That distinction has caused some confusion in the academic space. When I first came to the academic world of technology licensing, I was told that we could not license know-how because universities did not have trade secrets. So, we have a lot of know-how. We probably don't have a lot of trade secrets, at least on the research side, but we surely have a lot of know-how, and we surely can license that know-how.
So, Wes, that was a really great explanation. So I wanted to ask you, when you're evaluating the know-how you have, how do you decide whether to treat it as a patent, something you're going to file a patent on, or keep it as a trade secret? And what are some of the key differences between licensing know-how and other forms of intellectual property?
Well, there are a lot of reasons why you might not patent something that would be a trade secret or know-how. A lot of know-how isn't patentable. A lot of trade secrets aren't patentable. I don't think that the Coca-Cola formula, I'm not sure the Coca-Cola formula would be patentable. It may be. Maybe it's a special composition of matter. I don't know. But, there are just some things that you don't want to patent. You don't want to patent a trade secret, for example, because then you publish and everybody knows your trade secret. So they wouldn't publish the Coca-Cola formula for that reason. So those are some of the decisions. Remember, my client was doing classified work. We couldn't file patents on those things. So there's a lot of reasons why you do it. In the university space, a lot of the potential know-how that we have to license, is probably not the patentable part, of the invention. And so you often see, patent licenses that include know-how, because while you have the patent, which is the patentable thing, let's say it's a new composition of matter, you may have lots of know-how in how to construct that composition of matter. So you have a new molecule, the patent describes the molecule, shows all the chains, the chemical chains, and so on, but usually doesn't say what are the processes you need to create this particular molecule. And that part of it could be the know-how. I have a client right now that has a molecule, and it's very, very expensive to produce, except we know how to produce it much more cheaply than the rest of the world does. We don't patent that piece. That piece is our trade secret. So, there's lots of reasons why you do and you don't, but there's also some natural reasons, because it just doesn't qualify for patent, or it's not the kind of thing you patent. And in the university space, even though we publish a lot of things, you would typically publish the molecule and what the molecule does, but it wouldn't necessarily be interested to the scientific community, all the 3, 4, 5, 6 specific steps used to manufacture it. So that's, again, another reason why we do have, trade secrets or a know-how that's not generally known to others, that we do have the ability to license and license legitimately.
Now, when you're crafting a know-how license, especially when we're talking about material that you just mentioned that isn't patentable, how does the language in that particular agreement look like? What language in particular do you use?
Well, the real trick in know-how is you have to really describe what the know-how is you're going to give to the other party, and there's lots of different ways to do it. You often you talk about in the issue with my former client, we talk about giving them the technical specification document. There are certain terms that are used in the industry, in the engineering industry, for those things. But unlike patents or copyrights that have legal protections in the law around them, there's no specific legal protection, for your know-how. If I give you a patent and I say you can use this patent for this process, and you use it outside of that process, you violated my patent, and the law says you did, and I can get whatever the law says I can get. With know-how, you have to describe the know-how, and then you also have to make sure your document has the descriptions of the different things that are specifically allowed, and maybe specify also things that are particularly not allowed, where that's important to specify the things you can't do, as well as the things that you can do with regard to the know-how. And of course, with know-how, because it's a secret, if you will, there's confidentiality provisions that you have, even though your typical license would have a confidentiality clause as well, typically. But in the know-how, that clause is much more important in terms of the things that you're going to disclose and that you don't want then to publicly disclose to others.
Now, let's talk a little bit about non-exclusive license drafting. Walk us through the process of how you draft a non-exclusive license for know-how. For example, give us some of the key elements that you include, and maybe tell us a little bit about, in all your years of experience with maybe some of the things you've seen in terms of mistakes when people are licensing know-how.
Okay, well, I don't really think of exclusive versus non-exclusive as such, only because I find them very similar, except in one case you say to the person, you're the only one I'm going to do this with, and in another case you don't. There is a big difference, though, in terms of the safety. When you grant a non-exclusive license, it's a lot safer, if you will, because that person has the right to use the technology, but they don't have any exclusivity, which means by definition they're not prohibiting you from using it, and they're not prohibiting you from providing licenses to third parties. In an exclusive license, you're granting somebody an exclusive right. You have to make sure that you retain your own rights to practice that technology and that know-how, because that know-how, especially in the university space, that know-how is the life of the inventor of the know-how, or the creator of the know-how, and they have to continue to be able to use their know-how, and continue their career. So it's critical in the exclusive license to make sure you have the right to use that know-how yourself. And secondly, you have to be real careful in terms of the drafting in the exclusive license to define the field. I mean, that's tough in a patent license too. Some of the difficulties that I faced with clients over the years are situations where the field was well defined at the time, but the science changed. And just a simple example, you license one field for oral pills and one field for injectables, and now we have patches you can put on the skin. Which one gets that?
Where does it fall?
That?
Yeah, exactly.
Yeah. So, and it's the same thing when you're trying to do an exclusive license in know-how, maybe even a little trickier in the know-how space. So those are the challenges. When you're drafting an exclusive license, they're not as difficult, in drafting a non-exclusive license. Other than that area, all the other things, are the same, particularly the confidentiality provisions.
Now, Wes, I wanted to ask you, why do you prefer to structure a know-how license like you would a patent license, and what benefits do you think this approach offers to both the licensor and the licensee?
Well, we structure know-how licenses are structured very much like patent licenses. There's a lot of advantages to that. First off, a lot of the terms are the same. Your general terms are going to be the same, and your field of use, if it's an exclusive license, your field of use, the fact that there is a field of use, is going to be the same. And structuring the license like that is also more familiar. We're used to doing copyright licenses and patent licenses, and how they look, and then particularly in the university space where you have a lot of levels of knowledge and expertise in various offices, and so the know-how license looks a lot like a patent license, but for those extra terms that you have to have when it's know-how, when there's no general legal protection. There are around trade secrets, but it's not about the usage. It's about the secrecy part. But in know-how, you have to make sure you add that, to your contract. And also the description is so important, what the know-how is and what specifically you can do with the know-how. And of course, the biggest trick is, as I always say, you teach them everything that they need to know, but you don't teach them everything that you know.
Exactly. And when you're approaching or presenting these types of know-how deals to a potential licensee, how do you describe the nature of the deal without explicitly calling it a know-how deal or without releasing specifics on the know-how?
Well, I generally do just call it a know-how deal. The title that I used with my client I spoke was Process and Product Know-how License Agreement. So it just sounded like any other kind of a license agreement. And I think it, the difference, the really difference in the nature of the deal is that the party on the other side understands they're not getting patent rights, they're not getting copyrights. They're getting some limited right to use some know-how, and you're going to provide that know-how. You're going to provide that know-how to them, and they have the obligation. They have the obligation to maintain that know-how as not public information. And so that the licensee on the other side generally knows that and understands that. And usually they come to you, and they, in the university space, we publish a lot of stuff, and they come to you for those things. And in the case of the particular client, the entity that actually came to us most often was the government, who said, "Look, we're going to put out an RFP, for this, and we will let it be known that it's your technology." And then what would happen would be the people that wanted to bid on the RFP would come to us, and we would give them initial license that allowed them to review the technology. They knew what they were talking about and could form their bid, because they then would learn what they had to do. But that license did not include the right to produce products. They had to take a second license. If they got the bid, they had to take a second license, to actually have the right to actually use the users. So that's some of the nuanced differences in how know-how can be licensed, because it can be licensed strictly for evaluation purposes. It's for people to evaluate it in their process. So you give them a license to use it, to try it, and so on, but don't give them a license to make any products with it, unless and until they decide to make a product. And depending on the product, of course, you can have royalties. You can have all kinds of things that are similar, to patent licenses, although a lot of know-how is process-oriented, and so it gets licensed sort of on an annual basis and not necessarily, on a per-product basis, because a lot of times it's internal process and how you make things, and a lot of those things are made for internal use and not necessarily for a product that gets sold. So there's a lot of nuances, later on in the license that often come about, that's so dependent on the deal.
So to your last point there, so it would be kind of just like an annual kind of maintenance fee or a fixed fee per year to license some of that know-how that was process related.
Yep. And you could tie it to a lot of different things, and it's so dependent. It's like all the deals. Lawyers get criticized when people ask a question, you say it depends. But in fact, it really does in this case. And that's what makes it hard, and why, it's a little more difficult than patent licensing, because I think it requires, a deeper understanding between you and the client, or in the case of the university space, you and the inventor, to really understand, how this know-how is used and what it's used for and what its potentials are, in order to be able to draft a license that's appropriate for both parties.
Yeah, absolutely. And I would think also some creativity must be involved too, because like you said, depending on how the know-how is involved with other technologies and how it's used, it sounds like there's a lot of room to be creative, that there's no one-size-fits-all type of situation at all.
Yeah, I can tell you 40-some years of experience and seeing all kinds of different things that are done is very helpful.
Yeah, it sounds like you have a tremendous breadth and depth and knowledge on this. And, that leads me to ask, how do you make sure that the terms and conditions that are typically set in these deals are fair and beneficial for both parties? I mean, you've got, in your situation, working with the government, trying to make sure that these agreements are equitable. Can you share with us some of your experience in that regard?
Yes. Obviously it's totally dependent on the deal, but my deal philosophy has always been that the goal in the negotiation is to give the other side everything they need, while preserving for you or your client everything that you need. And then, of course, if one party, if either party can get some extra things that they want on top of that, that makes a really good deal. I've never subscribed to the philosophy is, let's take advantage of the other side and get as much as we can. Those are the deals. I started my career as a litigator. Those are the deals that fall apart. Those are the deals that get litigated. And so you don't want that. The whole idea of making a good contract is that both parties carry out the contract, and the contract is successful for both parties. So again, understanding the particular know-how and understanding what the other side, how the other side's going to use it, and how does it benefit them, is very important in trying to get to that deal that's going to be fair to the other side, and that's going to make the other side want to stay in the deal and be happy to pay you, the money. When they're happy to pay you whatever compensation for the deal, they tend to do that, as opposed to being unhappy and then wanting to get out of the deal or slide around there. So that's what I try to do in any deal and try to understand that. And so I try to negotiate with the other side and get an understanding of what they're going to do and how they're going to use this, and what they need, and try to come up with a fair compensation. And that's why you end up with some of those odd compensation things. Sometimes it can be product based, but other times it has to be based on something else. Sometimes it's based on annual sales of the whole company. Depending on exactly where that deal fits and how that know-how fits in making the other company successful. Know-how can allow a company to gain market share, and you can price a know-how deal based upon the gain in market share. So it's very dependent. But if you take the time, and again, I always say that contracts are only as good as the integrity of the people that sign them. And again, that's another part of the deal. It would probably pain you to know that there are companies in the military, aerospace, that cannot be trusted. Sometimes you have to do business with them anyway, but when you do, you structure your deals a lot different. And it's the same in know-how deals. You try to find out as much about the company, and you try to learn and get the sense of how trustworthy are they going to take care of your intellectual property, and you can draft your terms to protect your client accordingly.
Now, Wes, a little bit earlier, you mentioned that know-how licensing can be hard. And obviously, you've got a lot of experience, and I'm sure you've run into your fair share of challenges over your career. Share with us what some of the common obstacles were that you faced when you were licensing know-how, and how did you address those to overcome those challenges to ensure that the agreement was successful?
Yes, well, again, one of the biggest challenges is teaching them what they need without teaching them everything you know. And that was we had a funny situation with one of those companies, involving production of carbon fiber things, and we showed them how to do what they had to do to make their project, and they thought they knew what we knew, and so they went off on their own and bid on another project and were a spectacular failure because they didn't understand all the chemistry and the science behind what we had taught them. And taught them how to do. So it's important if you can do that. But for the licensing associate, I think that one of the biggest challenges is knowing that you need to know a little bit more about the know-how and how it's used. That you might need to know about the patent. You can license a patent without knowing a lot about exactly what the patent does and how the patent works. It's harder to do that appropriately, with know-how. When you're trying to sell know-how, you're in a licensing office, you want to sell know-how, convincing the potential licensee of the value of the know-how without disclosing all of the nuances of the know-how is a little more difficult, than a patent, because a patent, again, part of the idea of the patent is you tell everybody about it. In return, you get protection, for a period of time. And of course, obtaining fair value, is a challenge because it doesn't often lend itself to royalty type standard licenses. So those are some of the challenges. There are other challenges in defining know-how. Sometimes when you're involved in projects where you're doing collaborative research agreements, defining know-how. Once ran into a problem where the results of the research were defined as the confidential property of both parties. The university party couldn't publish, couldn't use the information to get any future grants. Almost shut down the career of the faculty member. I was only glad that they hadn't run that agreement through our office before they signed it. So we hadn't seen it ahead of time, and we managed to fix it. But there are little nuances of things like that can present challenges that you don't expect until they come up. Drafting the protection provisions are a big challenge. because they're different, than they are in patents. In patents, your biggest protection provision that you see in a typical patent license are the field of use and the territory. It's non-exclusive or exclusive worldwide. All fields is easy, and when you limit it in patents, you typically limit to field and territory. But in know-how, it's a little harder because know-how is typically used for something, and you really want to talk about how it's going to be used. And the other thing is, it's very difficult to determine whether know-how is used in the wrong way. If you produce a product that has my patent in it and you haven't paid me for it, you could. There are ways to find out if a patent is infringed in a product that's being sold. But with know-how, how do you know if they used the know-how to do something else that isn't your product? Sometimes you can tell because they didn't know a thing about this. Like, let's say you're doing specialty coatings, and they didn't know a thing about specialty coatings, and all of a sudden they're making new products with specialty coatings very similar to yours. But again, it's still very hard to prove. And so that kind of a license would say something like you could only use it for this coatings, and if you use it for any coatings of any kind, you produce any product with any coatings, specialty coatings, you got to come to us. But it's hard to get that negotiated. So that's some of the challenges. And again, I finish up with contracts only good as the word of the parties that are signing it. So you try to make sure you understand that, especially important with know-how licenses, I think.
Absolutely. And I wanted to turn and talk a little bit about nonprofits. And when you're dealing with nonprofits, let's say like research hospitals, do you approach the licensing of know-how differently? Are there any unique considerations or strategies that you employ in these instances?
Well, I could tell you in academia, we certainly respect our own nonprofit status. And we really try to honor the fact that we receive a lot of public support, not just governmental support, but private support. People give us money, because they support what we do. And so we're willing to freely share knowledge, which is why, we start out in the beginning of, do we really have, trade secrets or know-how? And so we do freely share these things. But we often make these things available with little or no cost to other nonprofits, and that doesn't mean you can't do it at no cost. I mean, one of the really good knowledgeable areas that we had at my former institution, was some surveys and expertise on how to avoid malpractice in the hospital setting, and there was a lot of work involved in all of that. So we had to charge something for it. In order to keep it going and to keep the research going. But you try to make it as reasonable as possible so that you can spread it out to as many people, as possible. So we consider that in our licensing. We've had many, and databases are like know-how. You got a database. It's not available to everybody. You've put it together. Access is limited. It's really sort of the same as know-how. And we had a lot of valuable databases at my former institution that we charged a fee to commercial entities to access, so that we could get the money to keep the database and keep the research going, collect the data, and categorize and so on. But we made it available for little or no cost to other academic institutions and nonprofit researchers. So you still need to do licenses because you need the protections that the license provides. You need the structure around the usage by the entity, but you can often make these available at little or no cost. As long as you've got the ability, to at least get the revenue that you need to continue. Either making the database available or continue the research that keeps the know-how up to date and valuable.
So, Wes, I want to switch gears again and ask you, how is the landscape of know-how licensing evolving, especially with the rapid advancements in technology, like with AI and other things?
Well, as mentioned, when I first came to academically, we didn't even think about licensing know-how. And I think, if I'm not mistaken, when I look back, and again, you've done this so long, you don't know exactly when things came into play. But it seems to me, I don't even remember seeing know-how in early patent licenses when I first started looking at patent licenses. And now every academic license will have patent and know-how in the license, partly because, we often ask, need to get, especially in biomedical field, you need to try to get at least some royalties beyond the expiration of the patent, because it takes so long to develop the biomedical product that your patents expire by the time the product comes out. And I frankly have never understood, why you can't have, royalties, after the patent expires, when the use of the patent is what led to the product that would, by which the royalties apply. But the court seemed to disagree with me on that.
They strongly disagree with you on that one.
They do, and I have no hesitancy saying I believe them to be wrong, because they don't understand business, how business is done. For example, if you had a startup company might not be able to pay you a lot of money in the early days. They might need that money to build a company. Why can't two business people agree that I'm going to get royalties for 20 years? And maybe if I get them for 20 years, they're 2% a year as opposed to 5%. So, again, that's a whole another topic we can have another podcast on. But I think our view of know-how, I think our view of whether we have know-how has changed. I think we now understand that there's a lot of things that we don't publish that are know-how, that are valuable, and that are not really appropriate to publish. That they wouldn't be that interesting in the scientific community, which is where we try to publish, or who we try to publish for. But they have value in the commercial environment. So I think we've come to understand that. I think probably we have more know-how even now, maybe than we did in the past, because there's so much depth to the research now, so much and depth and nuance to the research, and so much of the when I was at Hopkins, so much of the real expertise that we had was the experience of these researchers and the underlying knowledge that they had that allowed them to do the things that they did. They did it without thinking. They cultured these cell lines in a certain way because they knew that worked the best. Without really thinking about it. And when you look back on it, you say nobody else did it that way. That's why nobody else made these discoveries. And sometimes if you got the aha moment that maybe that is beneficial to research, you might get some publication to publish that for you. But I think we've come to realize that. I think when you talk about not just AI, the application of AI to existing data is a big thing that's just getting started now. I just saw something recently, come across about somebody promoting AI that can analyze your data better than you can. And so, that's going to be a new thing. So a lot of this data that we've had that we maybe haven't even organized, over the years, can in and of itself be valuable, and being able to apply AI to analyzing that data can give you a lot of nuances. So that data is like other know-how. It's stuff you have that nobody else has, that nobody else knows, that you can license out, that you can make available, and you can or cannot maybe allow other people to get AI access. Maybe you reserve that to yourself and you just let people get the snippets of the data and not download, all the data. So there's a lot of I think growth now, and that over the last 25 years. That makes us look at this, in an entirely different way. One of the more important inventions out of Johns Hopkins came out because one of our faculty inventors, at Hopkins, we give 15% to the faculty inventors lab, and that's unencumbered money. And this faculty inventor was able to hire some people to analyze 125 years of patient data that we wouldn't have been able to do without the money to do it. And because he had an idea that there was a relationship between a couple of different diseases. It turns out that there were, and it turns out that we had great diagnostics for disease 1 and no diagnostics for disease 2. And that led to a diagnostic for disease 2, one of the more important inventions at Hopkins when I was there. So again, data can be so important in so many different ways. And because with the computers and the AI and the ability to analyze things now, we can capture that data and put that data together, as opposed to having, hiring 10 people to go over manually the data. It's now available to be computerized and accessed very rapidly. And I think that's another change that's coming. And I think we're going to see more of these valuable databases or more valuable data, let's say, put into databases and providing the kind of information that invention, was based upon.
So, Wes, as a podcast comes to a close, I wanted to ask you, for those who are new to the field, what resources or training would you recommend to better understand know-how licensing?
Well, I try to attend as many autumn conferences as I can. And I don't think I've missed an annual for the last 20 years. And there's a lot of really good stuff there. And I know I've seen programs on know-how licensing, in the past. And I believe our Essentials course touches on that. And we're currently in the process of planning an advanced licensing course. And I'm on that committee. So I'm going to make sure I mentioned that we really should have some know-how. There should really be a discussion of know-how licensing in the advanced in the advanced licensing course. So Autumn is a great resource. Licensing Executive Society also has, is a good resource to look at as well. They deal with similar issues primarily from the commercial side, and there may be programs there. I think there's information online, although I took a chance to look at some of it in preparation for our talk today. Not all is relevant, not all is directly related, and know-how gets conflated with trade secrets. So you have to understand the nuanced differences between those two things. I think there's also a lot of resources of people within Autumn like myself that have a lot of background and experience and that are always willing to help. That you can always call upon to help. I actually do a licensing program that I do. I don't charge for it unless I have to fly to your place, and do it, or take a hotel or something. I ask you to cover my out of pocket. But I do it just because it's fun. Do it for officers that want to have their people, exposed to some nuances in negotiating, licenses and discussions of those clauses. A lot of it's going to be in this. We're going to put a lot of that into this, licensing course, that we're trying to put together now for Autumn. So, and there's a lot of folks that that do the same thing in Autumn. So, I think that there's no reason not to. I will bet you there's not an office here that couldn't find somebody, in our organization that would come to their office and help train their people and discuss these things. And I have an odd perspective on a lot of these things because I came out of General Counsel's office, so I dealt with the legal issues on the other side and the issues of when things go wrong, on the other side. So sometimes I talk about things that people think are a little esoteric, and some of the issues that have come up with faculty startups that I've raised that others haven't thought to be important, only because I look at it from the legal side as well as the licensing side. But there's a lot of folks and a lot of knowledge in Autumn. We have the Autumn listserv, and they're I love reading that thing. I learned so much. I've been in this business for 50 years now, and I still learn stuff. And I read every one of the posts because there are things that people know that I haven't thought of, that or situations that in even all these years I haven't specifically faced. And so that's another great resource, that people should take advantage of, be a part of, and you can pose a question. If you have a question, you're working on a deal, you got a know-how deal, and you got a concern. You can pop it up there, and I bet you're going to get 10 or 15 really good answers.
Yeah, definitely. Absolutely. Well, Wes, this has been fantastic. Thank you so much for joining us today and sharing your experience on know-how licensing. This has been incredibly insightful.
Well, thank you for having me. I enjoyed it.
And thank you to our audience for tuning in to Autumn on the Air.
Thanks for listening to Autumn on the Air with Lisa Mueller. Get social with us and share your thoughts. You can tweet us at AUTM or visit us online at AUTM.net. We'll be back next week on the air. Be sure to join us.